was serving as Cabinet Secretary for Internal and National Administration, a state office under Article 260 at the time of his nomination and parliamentary approval on the 18th of October 2024. He was disqualified from nomination by dint of Article 137, sub-Article 2B, rendering the entire process null and void ab initio. In contrast, the respondents who responded to this ground argued that the appointment process was completely legal and procedurally sound. They maintained that the filling of mid-term vacancy under Article 149, sub-Article 1 was an independent, sui generis, executive-led process, and that was distinct from traditional election or appointment. Further, it was the case that the restrictive disqualification in Article 137, such as the recruitment to the requirement to resign 6 months prior to or to secure multi-county voter endorsement, were tailored exclusively for general elections, not sudden midterm vacancies that demanded swift action to prevent a leadership vacuum. They contended that the initial formation of a presidential joint ticket under Article 148 could not apply to midterm emergency transitions. In addition, His Excellency Kindiki and the IBC specifically disputed the factual basis of the petitions, arguing that His Excellency Kindiki had in fact provided official gazette notices proving he had formally resigned from his cabinet position prior to his appointment as Deputy President. In considering the arguments of both parties, we turn to the relevant constitutional provisions, to wit Articles 137, 148, and 149. Article 137, sub-Article 2B, bars any person who is a public officer or is acting in any state or other public office from nomination as a presidential candidate. Article 137, sub-Article B, carves out exemptions for the sitting president, the deputy president, and members of parliament. Cabinet secretaries are not included in that exception. Article 148, sub-Article 1 also locks the qualifications of a deputy president candidate to those of a presidential candidate under Article 137. And Article 148, sub-Article 2 provides that there shall be no separate nomination process for the deputy president at a general election. Article 149, sub-Article 1, however, creates an entirely distinct pathway of filling a mid-term vacancy, as we have already observed, through a direct presidential nomination followed by a National Assembly vote. It makes no cross-reference to the electoral machinery or disqualification timelines that apply under Articles 137 and 148 in the general election context. A strict textual reading of Article 148, sub-Article 1 and Article 137, sub-Article 2B together would, if applied without contextual qualifications, bar an active cabinet secretary from nomination unless a timely resignation had occurred. However, we are satisfied that Article 149, sub-Article 1 creates a sui generis process that cannot be evaluated by mechanical application of the general election framework. Article 149, sub-Article 1 omits the standard electoral requirements, including the signature collection requirement and Article 137, sub-Article 1D, which signals the framers' intention that this provision operates independently of the general election machinery. To apply the strict disqualification timelines of the electoral context to a sudden or unforeseen midterm vacancy would risk creating an executive leadership vacuum of precisely the kind that Article 149, sub-Article 1 was designed to prevent. In any event, we are satisfied that the factual premise of the petitioner's challenge is not established on the evidence. The primary constitutional mischief targeted by Article 137, Subarticle 2B, is the prevention of active public servants from deploying state resources or conflicting institutional mandates to influence an election or appointment. The evidence before this court establishes that despite the unique circumstances of his nomination, His Excellency Kindiki formally resigned from the cabinet and gazetted his exit prior to taking oath of office as Deputy President. By severing his ties to the cabinet before assuming the deputy presidential office, the potential conflict of interest under Article 137, Subarticle 2B is designed to address was lawfully cured. The core integrity parameters of Chapter 6 and Article 137 of the Constitution were accordingly satisfied. This ground of challenge therefore fails. Before concluding on this issue, we must address whether the speed with which the state resolution, with which the Senate resolution was gazetted, the President nominated Professor His Excellency Kindiki, and the National Assembly approved the nominee, contravened the Constitution and the law. The petitioners argued that the extraordinary haste following the Senate's resolution of 17th of October 2024 revealed a predetermined impeachment process. In their view, the immediate gazettement, swift presidential nomination, and expedited parliamentary approval were evidence of a pre-arranged outcome. They contended that such speed undermined constitutional values of transparency, accountability, public participation, fairness, and constitutionalism. The respondents, including His Excellency Kindiki, took the opposite position. They maintained that the Constitution itself anticipates expedition in matters concerning high constitutional office. Once a vacancy arose in the office of the Deputy President, they argued the President was constitutionally bound to act under Article 149. Under Article 149, prompt compliance with such a duty, they insisted, cannot be itself amount to constitutional impropriety. Turning to the Constitution, Article 149(1, we have already reproduced that section, that article. I don't need to go through it again. Proceed. This provision leaves no doubt that the framers of our Constitution deliberately contemplated speed in filling in a vacancy of the Deputy President's office. The rationale is evident, and it is to safeguard continuity and the stability in the national executive by requiring prompt action. Judicial President reinforces this principle. In Ali Hassan Joho and another was a Suleiman Said Shabal and others, this is a Supreme Court petition number 10 of 2013. The court held that constitutional timelines are substantive requirements, not procedural conveniences, and cannot be extended by legislation or judicial discretion. Similarly, in the Mankin Aramat versus Harun Meitamei, Lenpaka, and two others, the Supreme Court, it's a Supreme Court matter petition. The court emphasized that constitutional timelines are binding commands, cautioning against reliance on Article 159 to circumvent them. The same principle was affirmed in Moses Masika Wetangula versus Muskari Kombo, Muskari Nazi Kombo, and two others, and in Harun Meitamei Lempaka versus Lempakian Aramat, where the Court of Appeal underscored the constitutional significance of timelines. Collectively, these authorities highlight that timelines serve vital public interests, including certainty, legitimacy, and orderly governance. The Supreme Court's decision in Raila Odinga and five others versus Independent Electoral and Boundaries Commission and three others, this is presidential petition number 5 of 2013, is also instructive. Addressing timelines under Article 140, the court had the following to say, and I quote, according to Article 140 of the Constitution, it is clear that In the resolution of presidential election disputes, I repeat that. According to Article 140 of the Constitution, it is clear that expedition in the resolution of presidential election disputes is of essence. End of quote. The court warned that prolonged uncertainty regarding the presidency undermines public interest. This reasoning reflects a broader constitutional philosophy that uncertainty in the occupants of high office is detrimental, and the Constitution deliberately establishes mechanisms to ensure continuity. Applying these principles, we are not persuaded that the prompt gazettement of the Senate's resolution was unconstitutional. Once the Senate concluded its process, the deputy president ceased to hold office, and nothing in the Constitution required a waiting period before gazettement. Likewise, the president cannot be faulted for acting swiftly under Article 149. He was constitutionally obligated to nominate a replacement within 14 days. Compliance with this duty cannot be construed as wrongdoing. To hold otherwise would penalize constitutional actors for fulfilling their obligations. The same reasoning applies to the National Assembly. Article 149 allows up to 60 days to vote on a nomination, but it does not require Parliament to exhaust that period. Acting sooner than the deadline is not evidence of illegality. Speed alone does not establish predetermination. The law requires objective proof that a decision maker had closed their minds before exercising power. Mere expedition does not meet that threshold. We therefore find that the gazettement of the Senate resolution, the present nomination of His Excellency Kindiki, and the nomination National Assembly's approval did not contravene the Constitution simply because they were undertaken expeditiously. I will now turn to the constitutional processes. Under this heading, this court is called upon to interpret Articles 144 and 145 of the Constitution to determine whether the Senate was obligated to establish a special committee to investigate the charges against the deputy president, or whether the formation of such a committee was discretionary. The court is equally invited to examine the procedures applied in the impeachment process, with particular focus on Article 150, sub-Article 2, and the extent to which, if at all, the Senate ran afoul the Constitution in that respect. Starting with the first issue, the dispute before us brings into sharp focus the jurisprudential tension embedded in Article 145 of the Constitution, and more particularly, Article 145, sub-Article 3b of the Constitution. Article 145, sub-Article 2 and sub-Article 3 detail the provision of removal in the following terms. I do not need to read those ones, those provisions, and I proceed. The true import of Clause 3b cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of historical continuum just a minute. Yes, I proceed. The true import of Clause 3b cannot be discerned in isolation. It demands a historiographical examination and a forensic appreciation of the historical continuum of Kenya's constitutional reform. Constitutional interpretation, particularly in matters touching on the architecture of the governance, must be informed by history, for history illuminates the intent of the framers, constitutionalizes the context, the text, and guards against distortion that arise from reading provisions in a vacuum. As the courts have consistently held, constitution is not merely a legal is not a merely legal instrument, but a living charter whose meaning is enriched by the struggles, compromises, and aspirations that birthed it. Accordingly, this inquiry necessitates tracing the evolution of impeachment clause through the Bournemouth draft, the Wacko draft, and the harmonized draft to appreciate the context of Article 145, Subarticle 3B was ultimately incorporated into the Constitution. Article 164 of the Bournemouth draft outlined the procedure for impeachment, vesting the Senate with ultimate authority. It provided that upon receipt of a resolution from the National Assembly, the Speaker of the Senate would convene the Senate, and if the motion was passed, a special committee of the 13-member will be appointed to investigate the matter. The language of the Bournemouth draft was rigid and prescriptive. The investigatory phrase was mandatory, and the committee route was the inescapable mechanism for digesting evidentiary complexities prior to a final vote. If the committee found the allegations unsubstantiated, no further proceedings would ensue. For avoidance of doubt, it provided as follows. The Speaker of the Senate shall, if Senate is then sitting or has been summoned to bring the motion to the notice of the Senate for the consideration within 7 days, or if Senate is not then sitting, will summon it to meet within 21 days of the motion, 21 days of the notice to consider the motion. If a motion is passed under Clause 3, the Senate shall appoint 13 of its members as a special committee in accordance with its standing orders of the Senate to investigate the matter. If the special committee shall investigate the matter and shall, within 10 days, report to the Senate whether it finds the particulars of the allegations against the President to have been substantiated. End of quote. Similarly, Article 155 of the Wacko draft mandated the formation of a special committee of 13 members of Parliament to investigate allegations once an impeachment motion was initiated. The provision was explicit and inflexible, leaving Parliament with no discretion. The committee route was compulsory, and the President retained the right to appear and be represented before the committee. For clarity, we have reproduced that one as well, but I will not go through it. I proceed. The harmonized draft of 2009 and its subsequent revision in 2010 represents the constitutional settlement now embodied in Article 145, which is the subject of contestation before us. To our mind, there appears to have been a deliberate harmony in the manner the previous drafts treated the committee stage of the impeachment proceedings. We are convinced that the framers intended to preserve this consistency across the drafts rather than to depart from it. This conclusion is fortified by a wholesome reading of the Constitution, which we explain in detail. Interpreting the text before us requires a careful and nuanced exercise in constitutional interpretation. Fortunately, the Constitution itself provides guidance on how it should be read. Articles 20, Subarticle 4, and Articles 259, Subarticle 1 establish the interpretive framework. Article 20, Subarticle 4 directs courts when interpreting the Bill of Rights to promote the values of an open and democratic society founded on human dignity, equality, equity, and freedom, while giving effect to the spirit and the objects of the Bill of Rights. Article 259, Subarticle 1 further commands courts to interpret the Constitution in a manner that advances its purpose, values, and principles threatens the rule of law, protects human rights and fundamental freedoms, permits development of the law, and contributes to good governance. Over time, our courts have consistently emphasized that the 2010 Constitution demands a transformative approach to interpretation. Recognizing its highly progressive nature, courts have articulated several interpretive canons. In David D. and others, such as AG, the High Court, that is the BBI case, the High Court identified four guiding principles: that the Constitution must be interpreted holistically, that it should not be approached with rigid formalities or treated as a mere statute, that its own theory of interpretation must be applied to safeguard its values, objects, and purpose, and that non-legal consideration are essential to uncover the true meaning and values. The Supreme Court, in the matter of Kenya National Commission on Human Rights 2014, clarified that a holistic interpretation requires contextual analysis, which means reading provisions alongside and against each other, informed by history, disputes, and prevailing circumstances. Similarly, in the Tunyefuza versus AG case, the Ugandan court stressed that a constitution must be read as an integrated whole, with each provision sustaining rather than undermining the others. The principle that the Constitution must not be interpreted through rigid formalism was also emphasized by the Supreme Court in Interim Independent Electoral Commission 2011 and the Communication Commission of Kenya versus Royal Media Services 2015. The courts observed that constitutional interpretation requires more than positivistic approaches. The court noted that Articles 20, Sub-Article 4, and Articles 259, Sub-Article 1 incorporate non-legal considerations such as historical, social, cultural, and political realities that must inform judicial reasoning. The court highlighted that Kenya's modern Bill of Rights envisages a human-based approach and social justice-oriented society, and judicial authority derived from the people under Article 159, Sub-Article 1 must reflect these values in court decisions. The former Chief Justice Emeritus Mutunga, in his concurring opinion in the Speaker of the Senate and another versus the AG, this is 2013 reported, also underscored that constitution making was an ongoing process, and acknowledged that compromises in drafting often create vagueness, and it is the court's responsibility to resolve contradictions and clarify gaps. In his words, I quote, "Constitution making does not end with the promulgation. It continues with the interpretation." Finally, the Court of Appeal in Center for Rights, Education and Awareness, and another versus John Harun Mwau, 2012 reported, linked constitutional interpretation with the statutory interpretation principles. It reiterated that courts must avoid absurd, unpracticable, illogical, and artificial results, and must always strive to serve the public interest. Fidelity to both the letter and the spirit of the Constitution requires interpretations that advance justice, rationality, and the common good. Guided by the interpretive principles discussed above, we now turn to examine the purpose and the intent of Article 145, Sub-Article 3 of the Constitution. We do so with full appreciation of the demands of judicial humility and the doctrine of stare decisis, which binds inferior courts to the pronouncements of superior ones and is the bedrock of coherent and predictable legal order. Our analysis is therefore offered within that framework, not as a departure from it. We are aware that the Supreme Court has determined the question in the Sonko decision, and we are mindful that the suggestion we are advancing in this discussion will build upon the existing jurisprudence and contribute to the broader legal discourse on this question. It is in that spirit and with deference owed to the Supreme Court that we nonetheless set out the following reasoning. Having already traced the historical development of this provision, a comparison of the earlier drafts with the current text